Boom! What a win! Hi, I'm Ryan Flugaur, Vice President with the National Association for Gun Rights, and today let's talk about the federal district court ruling that came out yesterday, striking down the federal ban on young adults aged 18 to 20 from purchasing handguns. The ruling was issued by Judge Robert Payne out of the Federal Eastern District Court of Virginia, in the case of Frazier versus the ATF. And it's now the third pro-gun ruling on the matter, following the Supreme Court's 2022 pro-gun Bruin decision. This is a huge policy win for gun owners. Even if you are over 21, this gets to the core of constitutional law. But before I get into the details, please slam that subscribe button so you can follow everything that's going on in the legal world of the Second Amendment. Click a link in the description to sign your petitions to your elected officials, and head on over to gunrights.org so you can read the latest in our legal effort to end gun bans for good. For far too long, federal law has arbitrarily denied Second Amendment rights to military-aged adults, folks who are able or required to fight for their country in war using guns, yet somehow the government denies them the very same constitutional rights they're fighting for when they come back home. Just to give you an idea of how ridiculous and arbitrary this law is, it's 18 United States Code, Section 922A5 and B. It was signed into law by President Lyndon Johnson as part of the Gun Control Act of 1968, but it only applies to handguns, at least insofar as how the ATF has interpreted it since 1983. That's right, federally speaking, there's never been a prohibition on the same young adults from purchasing rifles or shotguns, and that's a good thing. But the law only bans purchase, not possession, so it's generally been legal under federal law for law-abiding young adults to receive a handgun passed down generationally from a family member as a gift, or even carry it in public, except in anti-gun blue cities and states with more restrictive and overlapping laws. So if all this is legal, then why ban only the purchase of handguns to people who are adults? You mean to tell me that young single mothers don't have the right to buy a handgun to defend the lives of themselves and their children from violent exes in their own home? Or that college-age students can't buy a gun to conceal carry while walking through the quad at night to protect themselves from stalkers? Yep, that's exactly what this law was designed to do by the radical anti-gunners who passed it, and for all of the cities and states that have passed similar laws since. Sadly, even politicians in deep red Texas tried to expand this ban on the state level to include virtually all firearms just last week in response to the Allen shooting, even though that nutcase was in his 30s. And even though that bill flies in the face of another Texas ruling that came out in the Fifth Circuit against another similar age-based gun ban. Thankfully, that law failed to pass. And, frankly, this is just another example of gun control that does not work. It's inconsistent with the text, history, and tradition of the Second Amendment as required under the Bruin decision. In fact, the opposite is actually true. Back during the era of the Founding Fathers, there were laws on the books that mandated gun ownership for young folks. So for the sake of the Second Amendment, and frankly to help protect politicians in both parties from their own dumb idea fairies, this ruling from Judge Robert Payne is very much welcomed. Here are a couple of quotes taken straight from his ruling. Quote, "It's hard to conclude that 18 to 20-year-olds have no Second Amendment rights where almost every other constitutional right affords them that protection." And then, quote, "Under the analytical framework established in Bruin, the government simply has not met its burden to support the finding that restrictions on the purchasing of firearms by 18 to 20-year-olds is part of our nation's history and tradition. Founding-era militia laws provided circumstantial evidence that 18 to 20-year-olds could purchase, own, and use arms. These militia laws and the cases interpreting them further support the finding that 18 was the age of majority for acquiring and possessing firearms in the founding period. There is no direct evidence of age-based firearms restrictions." And finally, here's this bombshell quote. "As articulated in Heller, the Second Amendment does not serve to grant a right, but rather preserves that right that the people already possessed. Therefore, to keep him bare serves to identify the right protected, not define the right in the first instance." So those are some great quotes from that ruling. But as far as the applicability of this ruling, does that mean you can walk down to your local gun store and buy a gun if you're 18 to 20 right now? Well, that's where things get a little bit more dicey. Disclaimer, I am not a lawyer. This video is not legal advice, nor is it a substitute for talking to a local attorney familiar with firearms law in your area. This case is a huge win in federal court, but it only struck down the federal ban. Picking apart the patchwork of state and local gun bans in court to the point where Soros-backed prosecutors are powerless to do anything about it will take some time. And so on that front, you have to be in a jurisdiction that does not have an overlapping 18 to 20 gun ban for now. You also have to be not on the prohibited persons list under 18 U.S.C. 922. So that means you must be law-abiding. And if you're purchasing a gun from a gun store, you'll need to go through the NICS background check system. And well, that's a database that, if you may recall from some of our previous videos, Texas U.S. Senator John Cornyn, a Republican, just expanded last year to include scores of juvenile records, all without due process. And that's in addition to 25 million records of adults without due process. But I digress. The problems with the NICS gun control database is a topic for another video. Then you also need to find a gun shop that would be willing to sell to an 18 to 20-year-old a handgun. And that might not happen right away. That's because this is a brand new court ruling, and it may take some time for the fallout to propagate to the industry. After all, gun stores typically don't want to risk their licenses if there's any unclarity in the law, and they can refuse anyone as a right of business, being a private business. So not to be a downer, but don't be surprised if this isn't as quick as taking off your mask on an airplane. It should be, but the anti-gunners aren't going to accept this ruling without a fight. So where does this ruling take the movement next? Well, the next step for this is the Fourth Circuit Court of Appeals, where it's likely to be appealed to. The anti-gun lawyers will almost certainly ask the court to issue some sort of emergency stay on the decision so that the ban can remain in place. We hope they don't do that, but this is a court that hasn't exactly been the most friendly to gun owners on technical decisions in the past. In fact, prior to the Bruin decision, the Fourth Circuit threw out a similar case in FPC versus McCraw on a technicality that the plaintiffs aged out, which is a really cheap way of sidestepping this issue. But let me not underscore the significance of this ruling. It is an explicit ruling chastising this unconstitutional gun ban in the post-Bruin world, and that will have lasting effect in places that have similar age-based gun bans. And it's the only one to outright strike down the federal 18 to 20 handgun purchase ban statute. This is, again, sending shockwaves through the Second Amendment legal and legislative world. Congratulations to the litigants for this huge win. Though it's not one of our cases, it will help our case in all similar cases trying to take down this particular gun control. Take, for example, in Colorado, where we and our state affiliate, Rocky Mountain Gun Owners, are suing to overturn an age-based gun ban that was just passed and signed into law by Governor Jared Polis last month. That law is now very much on thin ice. And there are a total of 6 other rulings out there dealing with the 18 to 20 purchase law issue. In the pro-gun camp, there is this case we're talking about today, Frazier versus the ATF in Virginia in the Fourth Circuit. There's also Worth versus Harrington out of Minnesota earlier this year in the Eighth Circuit. And FPC versus McCraw, as I mentioned earlier, out of Texas in the Fifth Circuit. In the anti-gun ruling camp, at the district level, there's Reese versus ATF out of Louisiana, which is also in the Fifth Circuit, but that case hasn't reached the appellate level as the other case I mentioned earlier has. And there's also Laura versus Evenchek out of Pennsylvania in the Third Circuit. In that anti-gun camp, there's also the ruling out of Baucom versus Jackson in Georgia. And that's a similar state-level 18 to 20 ban case where the 11th Circuit Court of Appeals ruled, unfortunately, incorrectly. So the long story short is that this issue could be ripe for the Supreme Court to intervene with soon. And we will potentially be set up for a circuit court split on gun rights for 18 to 20-year-olds. But for now, we're hoping that the Fourth Circuit will get it right and allow Judge Robert Payne's decision to stand, which would mean the federal law banning adult handgun purchases would be toast. And if they don't watch out, because there will be an avalanche of cases coming down the pipe after this that will be enormous, including our case against Colorado's 18 to 20 ban. So thanks for watching, and don't forget to hit that subscribe button and check us out at gunrights.org.